Any federal action that violates the horizontal separation of powers imposed by the Constitution of the United States or that exceeds the jurisdictional limits imposed by the vertical separation of powers is therefore void, since the Constitution of the United States is the supreme law of the land. A law repugnant to the Constitution is void. An act of Congress repugnant to the Constitution of the United States cannot become law. The Constitution supersedes all other laws, and the individual's right shall be liberally enforced in favor of him, the clearly intended and expressly designated beneficiary. It's from the case of Marbury versus Madison from 1803. I've pointed out for years that unconstitutional laws are void, but it's nice to see a state legislature do so as well. After all the times people have misquoted Marbury versus Madison, it's nice to see it properly used here as well. There's more though. An unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be used as a legal cause of imprisonment. That's from Ex parte Siebold. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. That's Norton v. Shelby County from 1886. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. That's Miranda v. Arizona from 1966.